So friends, it's becoming painfully obvious what Trump-appointed Judge Aileen Cannon is doing. She is trying to intentionally avoid, perhaps even nefariously avoid, setting a trial date in Donald Trump's federal prosecution down in Florida. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, how much more delay in Donald Trump's federal criminal cases are the American people expected to take? Because what's going on in that little federal courtroom down in Florida, where Judge Aileen Cannon is presiding over the criminal case of the defendant who gave her her job, what's going on in that courtroom is unconscionable. And we're going to talk about why that is in a new segment, a recurring segment. Heck, it may end up becoming a daily segment, given everything Judge Cannon is up to. And if you don't mind, I'm going to take just 1 minute to tease what this new segment will look like. So friends, as we speak, Team Justice Editor Extraordinaire Peter Sobey is working on a short intro video, we call it a bumper, for this new segment. And the new segment will be called Cannon's Shenanigans. And there's a picture of Peter right there. Obviously, you'll notice Peter is in a wheelchair. Peter is a quadriplegic as a result of a diving accident at age 19. Peter is now in his mid-50s, and he is not only an extraordinary editor, he produces shorts every day of my Daily Justice Matters videos. You may have seen the shorts on Reels or here on YouTube or over on TikTok. He is not just a remarkable editor, but he is an author. He is a painter. He is actually a member of the MFPA, the Mouth and Foot Painters Association. And yes, Peter paints with his mouth. And if you're interested in knowing more about Peter, you can go to his website. It's petersoby.com, petersoby.com, and you can see some of Peter's remarkable work and learn more about his background and the amazing person he is. You know, he also travels around to schools and churches and civic organizations talking about, among other things, the dangers of diving in unfamiliar places. And I can't possibly put in one short video the amount of admiration, appreciation, and love I have for Peter Sobey. And as we speak, Peter is working on that new intro, that new bumper for the segment that will be called Cannon's Shenanigans, and that will premiere in tomorrow's Justice Matters video. Okay, friends, let's start with the new reporting about what's really going on in that federal courtroom down in Florida, and then let's expose and talk about Cannon's shenanigans. Here is the new Washington Post reporting. Headline, Golf Shirts and Classified Docs. New court filings show Trump's clutter. Pushing back on Trump's claim that prosecutors mishandled evidence, Special Counsel Jack Smith shows the evidence was a mess. And that article begins, Special Counsel Jack Smith revealed new photos in a court filing Monday evening that depict how haphazardly Donald Trump stored classified materials at his Florida property post-presidency, with shirts stuffed into boxes alongside the sensitive materials, newspaper clippings, and other mementos. The images, a grab bag of national security secrets, souvenirs, and various odds and ends, are part of prosecutors' effort to show that the dozens of boxes containing government materials at Trump's Mar-a-Lago residence and private club were so messy and disorganized that investigators could not preserve the precise order of the contents they retrieved. The Justice Department has released photos of the classified documents before, but the new filing offers the largest number of such images. In one, a sensitive document with redactions sits in a box atop an edition of the Washington Post with a front-page story describing Trump's difficult relationship with the FBI. Next to that box sit 2 cases of Diet Coke bottles. Smith filed the photos in response to an argument from Trump that the criminal charges against him should be dismissed because investigators messed up the precise order of the box's contents. Trump's trial, originally set for May, has been postponed indefinitely as U.S. District Court Judge Aileen Cannon hears a slew of dismissal and other motions from Trump's legal team, many of them far-fetched, and deals with other pretrial matters. In one of those motions, filed June 10, lawyers for Trump wrote that by not precisely preserving an exact copy of the contents as they were found, investigators essentially destroyed evidence and therefore made it difficult for Trump to employ some defenses at trial. Trump's attorneys suggested that they may try to argue the classified documents were buried deep in the boxes with a mishmash of personal mementos, and their client simply lost the sensitive documents and lacked the kind of knowledge that would amount to criminal behavior. Their argument, known as a spoliation of evidence motion, typically carries a high legal threshold. Defense lawyers would have to show that prosecutors intentionally destroyed evidence to convince a judge to dismiss the case. In his response to the motion, the special counsel said Trump's claims are meritless and contradicted by the evidence. The government filing includes transcripts in which people who worked for Trump told investigators the former president knew exactly where the boxes were and what was in them, often directing employees to bring a specific box on a certain occasion. Judges typically rule on long-shot motions without holding hearings. Cannon's tendency to hold hearings on many of Trump's requests has created a backlog of key decisions, delaying the original late May trial start date and making it unlikely Trump will stand trial in Florida before the presidential election. Okay, friends, let's start with the big picture. All available evidence tends to suggest that Judge Aileen Cannon is litigating at length frivolous Trump motion after frivolous Trump motion to avoid setting a trial date. Judges set trial dates. It's what they do. And often they do it over the objection of the defendant. Why do they set trial dates? Because all intermediate deadlines in the case, deadlines to file briefs, to have oral arguments, to have issues resolved, ruled on, all of the intermediate deadlines in a case are driven by the established trial date. No trial date, no intermediate deadlines. Friends, this ain't rocket science. What this is bias. This is favoritism that Judge Aileen Cannon is showing to Donald Trump. Let's take this one just mind-blowing example. She asked the prosecutors and the defense attorneys to propose trial dates. Jack Smith said July 8. Donald Trump's lawyer said we can go to trial on August 12. Easy call. Just pick August 12. Judge Cannon, give Team Trump what they requested. She said, no, I will set no trial date. Therefore, there are no intermediate deadline dates. The delay is the point. The other thing is many of these motions that Judge Cannon is litigating and litigating ad nauseum, which basically means until it makes us sick, she's wasting so much precious time. Okay, I took a little bit of liberty with the translation from the original Latin, but these frivolous motions that she's litigating and burning through all of this time are largely baseless. They're unsupported by the facts, unsupported by the law. Friends, as an example, let's just pick 3 of the frivolous motions that have been offered up by Donald Trump's attorneys. And for this, we'll have to do a quick Team Justice Law School class, but I promise it will be a quick one. So, 3 motions selected randomly: spoliation of evidence, a Franks motion, and the special counsel is somehow not lawful motion. Let's take those 3 on in rapid succession. Spoliation of evidence. It's a fancy word for the prosecutors destroyed all the good stuff, all of the exculpatory evidence, all the evidence that could have helped Donald Trump prove his innocence. That's a spoliation of evidence allegation. The problem is there's no evidence supporting that the prosecutors destroyed exculpatory evidence. So let me talk about how motions work generally in the criminal law. Let's just say, for the sake of argument, there are 500 different kinds of motions that a defendant could file in a criminal case. I picked that number out of thin air. There may be more, there may be less, but there are lots and lots and lots of motions, and frankly, defense attorneys can get pretty creative in the motions they filed. That's not a criticism at all, just an observation. Let's say there are 500 motions. But in order to file a motion in a criminal case, there's what's called the burden of production, and then there's the burden of persuasion. The burden of production means you have to have some facts, some evidence, and some law supporting your filing of the motion. And if you can't meet your burden of production, you know what the judge does? One word: denied. Let's move on to the next motion. She doesn't order extensive briefings and arguments and supplemental briefings and sit on it for months. No. If the defense can't meet their burden of production, then the motion should be denied immediately and summarily on the papers. If there's been a brief filed by the defense and the prosecutors file an opposition and it's clear it's frivolous, the defense can't meet its burden of production, it should be denied instantly on the papers. Not Judge Cannon. Doesn't matter if Donald Trump can't meet his burden of production. She's going to take her sweet time litigating all of these motions for months and months and months with no deadline set because she refuses to set a trial date. That is delay for delay's sake, but it's so much worse because the motions shouldn't even be entertained in the first place. So spoliation of evidence, let's take that one on. They're saying that, pursuant to a lawfully issued search warrant, the FBI went and seized all of these boxes of documents from Donald Trump's home in Florida, Mar-a-Lago. Let me tell you how we go about documenting the execution of a search warrant scene. We take photographs, the evidence technicians most precisely take photographs of the boxes as they first see them on the scene. They may open them up and just take an overall photo of what was in the boxes, what was visible once they were opened. Then they close them, they transport them back to the FBI headquarters or a field office, and then they go about meticulously documenting what was in those boxes. They will actually take everything out and lay it out on a table and specifically photograph each item that was removed from the box and document exactly what that item is. Maybe conduct some forensic testing on items for example, fingerprints or DNA. That is how we document. I was a prosecutor for 30 years. I reviewed more evidence of search warrants than I could ever recall. That's how we go about documenting what law enforcement sees during the execution of a search warrant. And Donald Trump's lawyers came in and said, well, wait a minute. You destroyed evidence. How? Well, because, yeah, in those boxes, there was just a bunch of stuff thrown in. Oh, there's a golf shirt. There's a classified document. There's a newspaper clipping with a picture of Donald Trump. There's a magazine article. There is an attack plan for a military attack by the U.S. on a foreign country that was prepared by the military. Oh, there are some golf balls. What you didn't do is say in the box, where was the classified document? Was it next to the golf balls? Was it next to the newspaper clipping with Donald Trump's picture? Because all of that is exculpatory evidence. It would prove that he didn't know what was in the boxes. That is, to use a legal term, nonsense. Nonsense that they destroyed, and the burden in a spoliation of evidence claim is that the government intentionally and basically nefariously destroyed exculpatory evidence. Nonsense. I'm not going to waste any more time because a judge should issue a one-word ruling. Denied. Next motion. Not Judge Cannon. We need to mull this one over for some months. The second motion that I've just randomly selected is what's called a Franks motion. Why do we call it a Franks motion? Because the name of the defendant in the case that was decided by the Supreme Court was Jerome Franks, a case decided, I believe, in 1978. I should have double-checked, by the Supreme Court. What is a Franks motion? Well, it says that if a law enforcement officer, like an FBI agent, goes to a judge and applies for a search warrant, and he presents or she presents an affidavit, which is just a sworn statement that law enforcement gives to the judge, setting out the evidence that they've collected during the course of an investigation that law enforcement argues makes out probable cause that a crime has been committed, and that evidence of that crime would be at Mar-a-Lago, and indeed it was. Well, a Franks motion says, if the law enforcement agent fills that affidavit with lies, in other words, the FBI agent swears to the truth and accuracy, because you swear to these affidavits under the penalties of perjury. If the FBI agent puts fact number 1 and fact number 2 and fact number 3 into that affidavit, that sworn statement, and gives it to the judge, asking that the judge conclude there's probable cause to issue the search warrant, but the FBI agent lied about facts 1, 2, and 3. No such facts existed. He or she just made them up. That would give rise to a successful Franks motion, because a law enforcement agent can't present a judge with a bunch of lies and then claim that the search warrant was lawfully issued. I've never seen a successful Franks motion litigated in my 30 years as a prosecutor. I know that there have been some that have been successfully litigated, but they're very rare. Why? Because law enforcement officers and agents, particularly FBI agents, I shouldn't single them out, but they're pretty meticulous about what they put in affidavits. That's my firsthand experience. They don't lie in their affidavits. So that is a frivolous motion. And Donald Trump likely can't carry his burden of production, which you need to satisfy if the motion is going to be heard at all. So Judge Cannon should have ruled with one word: denied. Next. The special counsel is somehow not a lawful thing. Denied. Next. Why do I say denied? Because we've been using independent counsel and special counsel in the United States in our criminal justice practice since the 1800s. I can't get the words out. That's how irritated I get sometimes. Since the 1800s. And courts have affirmed its legality and constitutionality over and over and over and over again. You know, most recently, even in this case in earlier attacks, or in the Robert Mueller special counsel appointment, over and over and over again. One word from Judge Cannon should have been used to resolve that frivolous motion: denied. But no, we're going to take months, because there's no way she's going to let this case go to trial before the November election. That's bias. That's favoritism. And as you've heard me say over and over again, in the federal law, 28 U.S. Code 455, for those of you still scoring at home, the federal law says if a judge's impartiality might reasonably be questioned, she shall disqualify herself. And on top of everything else that gives rise to Judge Cannon's impartiality reasonably being questioned, two of her colleagues on the federal bench in Florida told her, don't preside over the Trump case. Indeed, the chief judge, Judge Altanaga, appointed by President George W. Bush, told her, don't preside. That's the reporting from the New York Times. So I do believe at some point it's inevitable that a motion to recuse her, a motion to remove her from presiding over the Trump trial and have a completely fair, independent, impartial judge, and one not appointed by Donald Trump, mind you, step in to take over, inevitably that motion will have to be litigated. It will have to be litigated if anybody will be willing to have confidence in the outcome of a trial, because I will not have confidence in the outcome of a trial that is presided over by Judge Aileen Cannon, because, you know, having a fair, impartial, independent judge, one who sets trial dates and deadlines and cares about the American people's right to a fair and speedy trial, like justice, matters. Friends, thank you for bearing with me through that long one. As I say, tomorrow with my Team Justice editor extraordinaire, Peter Sobey, will premiere the bumper for Cannon's Shenanigans, a new recurring segment that we'll be doing here on my Justice Matters channel. In the meantime, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.